otherwise unconstitutional plea or conviction would only be unconstitutional if Balzadar actually went to jail. Balzadar did not actually go to jail below. I'm sorry.
Just one question. The cases that you've alluded to are or are not cases where there's been a prior adjudication, as there has been here under a 440.
That is correct, except for People v. Ryan.
Are they? Or they're not, except for the one?
Except for People v. Ryan, you are correct, Your Honor.
Does this fact make a difference?
No, and I'll explain why. I don't believe...
It seems to me the very issue that you sought to raise in the suppression motion, which is an issue here, was raised in the prior 440, which went to the appellate term and not beyond.
That's true.
Why haven't you had why has your client not had his day in court?
I knew you were going to ask that. Exactly, my exact words are, why has your client had his day in court?
Well, we got the question. Now, what's the answer?
All right. The answer goes along with what I was just saying. The answer is, if I was forced, which I was in this case, I was told by the judge and by the DA, go to Suffolk County, and I did that. But just because I lost in Suffolk County doesn't mean I should lose in Nassau County. The reason is exactly the same as in Balzadar. It is constitutionally valid in Suffolk County. There's no reason to set this aside under the holding of Scott v. Illinois. My client did not actually go to jail on the first DWI in Suffolk County. There really is no reason to set it aside in that case. But that not being the issue before you judges, the issue here is it constitutionally valid for purposes of enhancement? That's where Judge Brennan and Justice Marshall and Justice Blackmun and Justice Stewart say, just because it's constitutionally valid for all purposes, which it might be, doesn't mean it's constitutionally valid for enhancement. Now, I did make a 440 quorum nobis, and I lost a 440 quorum nobis. But that doesn't make a difference in this case. If Balzadar made a 440 quorum nobis, he would have lost too. There was no reason to set it aside in the court of original jurisdiction. Secondly, without creating a remedy here, Your Honors, we are telling people on normal misdemeanor cases that they have to go to the courts of original jurisdiction in order to set their convictions below aside, or their prior convictions aside. It would be much more economical and much easier for the courts as well as the litigants if it could all be done at once.
Thank you very much, Mr. Bernard.
Thank you, Judge.
Mr. Nerkins?
Good afternoon, Your Honor. The question before this court is not, as the defendant just argued, whether it would be wiser or more convenient to accord him a specific remedy, similar to the one provided to recidivists, to collaterally challenge his predicate convictions that is being used to enhance his crime to a felony status. The legislature, in no uncertain terms, has refused to provide the defendant with this type of remedy. Rather, the issue that is before this court constitutes one of those extraordinarily rare circumstances where the defendant claims that some form of judicial remedy must be created in order to effectuate his right to collaterally challenge, presumably by way of a pretrial motion as the defendant did here, his predicate conviction.
But you see, he's being tried now for felony. He says, I didn't commit a felony. You tried me for a felony only because of this unconstitutional predicate. And I want that erased before you start to try me for this felony.
Your Honor, the conviction that he had in Suffolk County was a valid conviction. The defendant could have done, as the appellate division held, one of three things. The conviction in Suffolk County was a plea. The defendant could have moved, prior to sentencing, to withdraw that plea. The defendant did not. Granted, at the time of sentencing, this option is no longer available to him. After sentencing, the defendant could have taken a direct appeal. The defendant did not, and granted, after a period of time, this option is no longer available to him unless that defendant receives permission of the court for an extension of time to file an appeal. But the defendant still has a third option available to him. That option is the option to file a motion to vacate that judgment of conviction. And this motion can be made at any time. It does not have to be made within a prescribed period of time. In this case, the defendant made such a motion 15 months after, at least 15 months after the sentence was imposed. That motion
That's
was...
when he started caring about it.
He began caring about it when he was arrested for the second time. And the defendant was put on notice at the time of the plea that if you were arrested again, or should have been put on notice, or at least the statute, at least the law provides, that if you were arrested for a second crime, you were now a felony because of that prior conviction. The defendant at that point in time went to Suffolk County, filed a motion to vacate. That was denied. What the defendant is now asking is that a second court, a court of co-equal jurisdiction or even of higher jurisdiction, review the exact same issues that were previously decided in a 440 motion. That's a needless waste of scarce judicial resources and is simply unnecessary to ask for another remedy when there is a perfectly valid remedy available to the defendant. Now, the defendant refers to People versus Baldassar, or Illinois versus Baldassar, but there are several things to be kept in mind. Baldassar was a per curiam opinion in which there were two concurring opinions in which 4 out of 5 justices concurred, and there is the 5th opinion by Blackman. Blackman said that if the defendant was represented by counsel at the prior, then the misdemeanor conviction would have been valid for enhancement purposes. Indeed, the court in its per curiam opinion in footnote 3 seemed to suggest the same thing. What we have in Knack was a defendant who was represented by counsel. We are dealing with a counseled misdemeanor plea that separates this case from Baldassar, which was an uncounseled plea. In addition, the Fourth Department in People versus Sirianni, in overruling the lower court, stated that for certain instances, the defendant can voluntarily waive his right to counsel. And that voluntary waiver of right to counsel in terms of the entrance of a plea would not affect that validity of that plea for all purposes, including subsequent enhancement. An issue that was not decided by Baldassar because the 5 justices felt that it was an uncounseled opinion, an uncounseled plea that was not voluntarily made by the defendant. So Baldassar is inapplicable to this particular case.
I just asked a procedural question. In the 440 that was made, and I gather later appealed to appellate term, was the constitutional issue, which, but for the procedural problem that we have here, namely the availability of the suppression motion, addressed on the merits.
Your Honor, with respect to the issue of the Boykin rights, the poor allocution, those issues were raised in the Suffolk County motion and were denied by the Suffolk County Court. That denial was affirmed by the appellate term.
Was an application for leave to made with respect to that?
There was no application with leave to this court as far as I'm aware of.
Yeah.
Moreover, I don't think you can categorize the defendant's motion as a suppression motion. CPL 710 provides specifically what constitutes suppression. This is a non-existent motion.
I realize whatever it is, whatever the motion is called, and if it were available, the issue that would be addressed in that motion is the same substantive issue that was addressed and passed on and later appealed to the appellate term?
That's correct, Your Honor.
Okay. That answers my question.
If it's called a Knack hearing or proceeding, the only difference would be, as I understand it, the remedy, that in the coram nobis it would be vacatur of the judgment, and in this Knack hearing it would be suppression for purposes of elevating the Nassau County charge to a felony?
That's basically what I understand the defendant saying, but what the defendant is saying is that this court has to grant him this remedy because he has no other choice. He has no other remedy. He does have a remedy. He had at least 3 options. He took advantage of the 440 option. He filed a 440 motion. He had his day in court on it. What he's now saying is, I don't like what came out of that proceeding. I want to be able to challenge it again.
That was not necessarily an unfriendly question. What I was trying to determine, picking up on Judge Hancock's question, is whether there's anything else that differs other than the remedy, because otherwise the one may be subsumed in the other. If the coram nobis is the greater in the remedy that is available, and the issue advanced is the same, and what is being asked for now is on the same issue, a lesser remedy, then perhaps that answers some of the arguments that have been advanced to us by your adversary.
I think that it would raise more questions. For example, if there is such a thing as a Knack hearing, which the people obviously would oppose, and a court holds that for purposes of enhancement, the predicate conviction is improper, what does that do with respect to any further proceeding? What does that do with respect to this predicate conviction? What is the status of that predicate conviction? How far does one go? This, to some extent, was some of the questions that concern the Supreme Court in Baltazar, some of the issues that were raised by Justice Powell in his dissent, some of the very issues that concern Justice Atlas in the decision People versus De Jesus as to the ramifications of this if this type of hearing was held. What are you now doing with respect to that misdemeanor? How can it be valid for some purposes and not for all purposes? It confuses the issue.
It might be a very simple thing. It sits out there by itself, and if you did it right in Nassau County, you now have a new predicate for the 3rd time around to elevate it to a felony. But there's really no confusion about where the misdemeanor in Suffolk County is, just to answer your question or to follow it through to see how it plays out.
Well, there'd be no basis in Suffolk. The Suffolk conviction would be valid for the purposes of Suffolk. What happens in Nassau or in any other jurisdiction where this defendant might subsequently be arrested for DWI? Now, if he's subsequently arrested in Nassau, and because of a potential infirmity that's involved with this Suffolk conviction, in Nassau he's tried as a misdemeanor. He's convicted. Now he's arrested for a 3rd time. He now can claim not only that, can he reclaim that he cannot be charged as a predicate or raised to a felony level because of the infirmity already decided in Nassau with respect to that Suffolk DWI conviction, or can he re-raise that issue? Now he can challenge the Nassau conviction, both within Nassau and now in this 3rd court, so he's now being able to run to 3 courts, Suffolk, Nassau, and this new jurisdiction where he's arrested. It creates endless confusion. To some degree, what the defendant is trying to draw is an analogy with recidivist statutes. And the courts, and this court has provided, and the legislature have provided remedies by which defendants can challenge their predicate conviction prior to sentencing. In the courts that have held that the defendant could raise an issue, they have drawn analogies to recidivist statutes, but they never followed it through. They failed to recognize that the appropriate time to challenge a predicate conviction would be prior to sentencing. At that point, providing the court with the information as to whether or not the predicate conviction was validly obtained. Here, the defendant didn't even try to do that. He had a motion in Nassau County that was denied on procedural basis. The Nassau County Court basically said, it is improper to raise it at this time, you have to go to Suffolk County to raise it. The defendant then pled guilty, never attempted to re-raise this issue as on the merits that my predicate conviction was invalidly obtained. Thus, if you're going to accept the argument that the defendant does have an opportunity to raise it, he waived it by the manner in which he pled guilty and did not raise it before sentencing. In conclusion, the people would say that for this court to establish a new remedy when there are valid remedies already available to the defendant would be, in essence, a waste of judicial resources by providing the defendant with a second bite of an apple. And secondly, if this court is going to find that such a remedy should be provided, drawing an analogy to the recidivist statutes, this defendant waived his right by not following the procedures laid out by this legislature with respect to how to controvert a predicate felony that is being used for sentence increase.
Thank you, Mr. Durkin.
Thank you.
All please rise. Hear ye, hear ye, hear ye. All persons having any further business before this Court of Appeals, held in and for the State of New York, may depart hence, and appear here tomorrow afternoon at 2 o'clock, at which time this Court now stands adjourned.
Introduction to civil procedure.